Good afternoon, everyone. I want to welcome you to an armchair discussion with one of the leading environmental advocates in the United States. This event is underwritten by Fred and Charlotte Hubble and the Hubble Environmental Law Initiative here at the University of Iowa College of Law. I'm grateful to our faculty director of the Hubble Center, Shannon Raisler, right here in front, for helping to organize this. And our staff director, Blake Root, who's somewhere around here and worked so hard to put this event together. Grateful for that. And we have the new Hubble Research Fellow, Ingrid Gronsdahl, who's here. And we're so glad that this is really coming together. So grateful to Fred and Charlotte Hubble for funding all of the good work. By the way, there's still some people coming in. There's still some food out there either. Kierán and I won't be upset if you go get seconds. So please feel free to come and go as you like. Today, our guest is Kierán Suckling. Mr. Suckling is the executive director and one of the founders of the Center for Biological Diversity, an organization that has won an extraordinary number of cases in the U.S. courts, usually against the United States itself, or at least a component, the Fish and Wildlife Service, but also others. Kierán founded this organization with a couple of colleagues roughly 25 to 30 years ago, I think, and it now has 180 employees and an annual budget of nearly $30 million and includes more than 50 lawyers working across the country to enforce the Endangered Species Act. I don't think there's another organization, one as many cases in litigation against the United States. It's his organization. And been the catalyst for so much change. He's also developed a lot of wisdom and experience through all of this work. Kierán is not a lawyer. He was a PhD student and was headed with that direction, did not go to law school. But I've known him off and on over the years, and I've learned a heck of a lot from him about lawyering and about advocacy, even though he's not a lawyer, because he's a very good litigant, even though he's not a lawyer. And he's got some very important lessons, I think, for law students especially, but for all of us. And I would like to draw some of those out in the conversation. He uses the law more successfully than almost anyone. Some environmental activists are all about civil disobedience. That's not Kierán Suckling. He is a very aggressive enforcer of the law. He wants to see the law aggressively enforced. And I guess why don't we just jump right into the questions? Do you want to say anything before we begin with that?
I do enjoy civil disobedience. Don't have to choose.
He's also kind of contrarian. You will notice this about him. So we're here today to talk about the Endangered Species and Act, and I know you spend a lot of time in the weeds, and maybe less than the big picture because you're working in so many different areas. But I understand that the components of the Act involve sort of designation of species, that is, listing the species, that is, and then designation of critical habitat. Other components such as species recovery plans and that sort of thing. Can you talk a little bit about are any of those areas most important, or can you talk a little bit about your areas across the landscape of the Endangered Species Act?
Sure. So the main provisions of the Act that are most effective, most important for conservation are, one, the listing of species. Two, the designation of critical habitat for those species. Three is a requirement that the federal government will not drive any species extinct, that it will even affirmatively work to recover endangered species. And will do so by consulting with the U.S. Fish and Wildlife Service for terrestrial species, or the National Marine Fisheries Service for marine species. And then finally, the prohibition on on any person, agency, private party, of killing or harming endangered species without a permit. Those, I think, are the core aspects. Now, there's other aspects, such as every species shall have a recovery plan that are important, but not as important or not as influential. And the reason for that is the way the statute is written is they are not enforceable, which leads to a broader assertion. Let's say question, but most people make assertions when they claim they have a question. So I'm just going to make an assertion. If it's not enforceable, it won't work. That's why the enforceable provisions of the ESA are the most effective and important, although there are other ones. So I'll talk a little bit about each of these and our focus now. So the first one is this. So every species in the United States that is threatened with extinction or at higher level of threat, endangered of extinction, is supposed to be added to the endangered species list. And if it's not on the list, it is not protected. None of all the other stuff that flows happens unless it gets onto the list. And so the list is woefully inadequate. Many imperiled species that should be on the list are not on the list. And my group, since our start 33 years ago, has always had a very strong focus on getting species put onto the endangered species list. My group started in '89, and I think from right now there's about 1,863, more or less, species on the endangered species list. And of those, since my group started in '89, the center is responsible for about getting 80% of those species on to the list. We put a lot of effort into that. And there's a tremendous opposition to it because industry and ESA opponents, they know that all the stuff that will follow listing will not happen if you can intervene at this funnel and prevent species from getting listed. And there's 5 specific criteria for getting a species, for declaring the species is endangered. I won't go into details, but the point is it's specific. It's not like a general question or specific standards. They're good standards. They cover the issues. And the agency is only allowed to consider the best available science when making this decision. It's not permitted to take into account economic impacts of the listing. It's prohibited from taking into account political opposition. It's public favorability, etc. And this is one of the geniuses of the Endangered Species Act, and it's the same notion of exclusive focus on best available science is throughout the act, not in every single place. I'll talk a little bit about it later, but generally through most of the act. And while pretty much all environmental laws at one level or another say, you should follow the science, the scientific basis to all of them. The ESAs is more specific and stronger because it's not just pay attention to the science. It says the best available science, not just any science. And so that was a very important, I think, aspect of this law being written well. And so anyway, to get a species listed, we write these scientific treaties or competitions, where you'll outline everything that's known about the species, and you'll make the case that it's endangered, submit it to the agency, and it's supposed to process this. The law says expeditiously. You can imagine there's been a lot of litigation over what is expeditious and what is not. A lot of it starts Center for Biological Diversity. So we've written many native species petitions, get them into the hopper. The agency delays or ignores most of them. They file litigation, and we force them to do it. They yell and scream. If it's a not super controversial species, we quite often don't make the right decision. But if it's a controversial species, the species is going to have significant environmental impacts. The agencies are under great pressure on all manner of industry and political folks to not do it. And they'll make the wrong decision. They'll say it's not in perils, and then we litigate over that. Lots of litigation in this regard. And what's interesting here again is, I'm sure most people know, is attorneys or smart attorneys, there's a general principle that the courts should defer to the expertise of the agencies, right? You can't have federal judges just willy-nilly deciding that the science better than the agencies. It would be fairly chaotic if that were the case. So we've got a really big hurdle when we go into court, right? It's a stacked situation. By law, the court is going to defer to the agent's expertise unless you are able to sort of overwhelmingly show that it's not even close, that the agency is so far outside the bounds of fact and science that for a judge to declare that is not a judge intervening in the world of science. It's making sort of common sense clear ruling that the agency has really missed the boat on this. And again, when we're doing that, the standard is best available science, which is really helpful. So we're able to win almost all of those difficult fact-based cases because we only get that far if we feel that the science is really on our side. So we get the species listed. The agency is supposed to map out the critical habitat for every endangered species, which is the habitat that the species needs to recover. In other words, for its population to grow to the point that it's no longer endangered. And so that's an important aspect of this, because many aspects of the law are about don't hurt the species, don't make it worse. Critical habitat, this is what's needed to make it better, to get to the end of the object. So during the Reagan administration, 1983, well, step back to that. So species is listed as endangered. There are certain standards built there, right? You can't drive it extinct. With critical habitat, the rule is you don't directly regard the species, you say it's designated. So you're not allowed to destroy or adversely modify habitat. So it's a question about the habitat. It's not a question about the species. So these are two distinct prongs, two distinct goals that should be looked at independently. In 1983, the Reagan administration very purposely put out regulations that collapsed that distinction. And it effectively said to be adversely modifying the critical habitat, you would have to be creating these harms to the species. And that allowed the agency then to say, well, critical habitat doesn't matter. It doesn't add anything because there's not an independent analysis, independent standard. Therefore, we're just not going to do it. And after that time, so the Fish and Wildlife had been designating critical habitat, not always, but to the extent before that. And after that policy, it just stopped doing it. There was no more designation of critical habitat. And so when the standard came along, this was in the early 90s, we started getting a lot of litigation because we noticed this and saying we got to do that. So so we filed a whole bunch of lawsuits saying you're required to do this. It's this, that, and the other. I won't go into the details to try to evade this, but finally we were able to stack up a series of different legal precedents that declared the rating policy illegal and forced the agency to designate critical habitats for the species, which it almost always does now. We, since that time, we have gotten about, now it's about 780 million acres of land and water designated as critical habitat for endangered species. And to this day, a lot of our battles are about, are you harming the critical habitat of a listed species? And there's a bunch of details about that I won't go into. And then there's the consultation provision. So, well, I'll start with this one. Every federal agency is not only banned from about 6 they have a affirmative duty to recover the species. And what's interesting is every federal agency, and a lot of people think, oh, your Fish and Wildlife Service. Well, what about the Department of Defense? Very first lawsuit we ever filed was of the Mexican gray wolf, and it was against the Department of Defense. And what had happened was, at that time, there were no Mexican gray wolves in the West. They all occurred in zoos, captive breeding facilities. The Reagan administration illegally had declared the species unrecoverable. There's no provision in the Endangered Species Act to declare a species unrecoverable. And however, Jimmy Carter, it's just saying Jimmy got now. Carter, or someone working for Carter, from the Carter side, someone working for Carter noticed this provision, and Jimmy Carter ordered every federal agency to determine which endangered species occur in their land, if they had habitat for it that should be set aside as critical habitat. I ordered them to do this, and they proceeded to do it. Now, unfortunately, he put out this order late in his first year. I think it was shortly after that unfortunate wrestling match with the rabbit. You guys remember that? So he gets run out, and then none of the agencies did it except for the Department of Defense. It turns out it's the only federal agency which does what the president wants. Right? Everyone else ignores the president. Do the thing that they do it. So the military did this. So the White Sands Missile Base in New Mexico, they identified it as a place the Mexican gray wolf could live. So so there was an effort when this thing just started, a coalition of groups before us that was trying to get the general of the White Sands Missile Base to introduce wolves, and it's not because that was the best place. It's not, but there was a hook. There was something to hold on to and say, well, you said it was a good place. You should do it. And so, so they had a group called the Wolf Mexican Wolf Coalition, And for years, they would meet with the general and try to put some individuals on there. And the general didn't think it was a particularly good idea. And this went on and on. So then in the center, we started up and we joined the coalition. And we said, okay, well, what's the strategy here? And they said, well, strategy is, the general is old. And I'm like, they just required, doesn't the law say they have to do it? It says every federal agency will do this. Yeah. So we went and we started a new group called the Wolf Action Group of WAG. And we filed suit against the military. And they were shocked. They were like, oh, we're not subject to endangered species. That's not what we do. We kill people. And so we won that suit. Things happen years later. We'll stop in a while. Not ultimately military base, because that's another thing you can always do. Don't tell me when I'm supposed to do this stuff. But the military is the big dog. They get to do whatever they want. So if you sue the military and they don't want to do, they will make someone else do it. And so very often we've had situations where we sue the military and that just ratchets up the political pressure. All of a sudden the Forest Service comes in, do that. And that's exactly what happened in this case. This is a good strategy. Always sue the military. But where was I? Oh, so and that was, one of the, first early cases where people were going after non-environmental agencies, and not just say don't hurt the species, but you have to actually recover them. You have to do beneficial things for them. It's a really important area of law. And then finally, when a federal agency is going to do something that may harm endangered species, in order to execute its duty to not drive species extinct, to not unduly harm it, it's supposed to consult with the experts. So for terrestrial species, Fish and Wildlife Service, and Marine Species National Fisheries Service, and get their opinion on this. Which the agency does through the production of something called a biological opinion. So a lot of the work we do is, and others, is convincing what's called the action agencies, the federal agencies, often in the form of an injunctive order, to do that consultation, because the agency has a massive conflict of interest, right? Because they're the ones who wants to do this when you sail the mine where it is. The U.S. Fish and Wildlife Service and NIMS are supposed to have that as their interest. Their interest is the species. So, so lots of litigation over consultation. It's a very important aspect of the law as well. Maybe I've been talking too much. Somewhere along the way, I'll cycle back to recovery plans later. But those are the most important areas and subjects of massive litigation over the years.
Now, you have told me before that you are always bringing lots of cases, a lot of litigation, but that you don't like to staff a case with just a lawyer. And the example that you gave me the last time you talked to me about this was that you said that, a lawyer writes the press release about the case being filed and it says, United States Fish and Wildlife Service violates the law. That's the headline. And you said, and that puts everybody to sleep. But if you get a community activist or someone else to write the headline, someone that's better at sort of public communication, it's might be U.S. Fish and Wildlife Service causes the jaguar to go extinct in North America, and that one gets picked up by the New York Times, and that's the difference, I guess. Can you talk a little bit about your use of litigation, maybe not just for winning the case, but for as a vehicle to educate and that sort of thing, and how you strategize about that?
Yeah, sure. Obviously, I certainly do a tremendous amount of litigations. It's one of the most well known for, but nonetheless, litigation is it's just a tool to achieve environmental protection. You know, I mean, my goal is not to enforce laws. My goal is to protect species. And it turns out the law is a very, very good way to do that. And so I think a good part of our success, you know, is really always keeping that in mind. And usually, yeah, when we have cases, we're pairing up attorneys with rabble-rousing activists and media people, and so that we're working all angles of the issue, and very importantly, you know, really at all times, really communicating the value at play, right? So turns out, you know, America does not think the fact that someone was arbitrary and capricious is a big deal. Okay, we're all fucking arbitrary and capricious every day. Right? You know, that's not going to get you anywhere in this world. What's important is they were damming a river. They were driving the species extinct. That's what's important to the public. And so always keeping that in mind, coming back to that and talking to people in a way that they understand and what's most important to them is really important. And it's what builds support for the law, not the law, but the environmental protection. And it's particularly important in litigation because, you know, one of the things I like about litigation is that there's so many newsworthy moments in it. You know, there's filed a notice of intent, oh, now they filed the suit, oh, now they filed the complaint, and oh, they've asked for an injunction, and, oh, now there's a ruling. So it creates all these moments where you're able to go out to the public and talk about what's happening and remind them of the extinction crisis and remind them that, you know, very often the government could be private interests are hurting the environment when we expect them to not do so. And so those media moments, you know, have to be taken seriously and not just as a side effect or a side opportunity. You know, they're central to the whole thing we're trying to do. They're just as central as the legal filings. And so you really have to keep that in mind.
So the ESA has been a very good law. It's been very, very effective and partially in your hands, but in others. And I guess one of the questions that's always revolves around is the question of resources, and you brought it up yourself. The Department of Defense mostly wants to buy guns and missiles and bullets and not spend their money doing biological opinions or hiring others to do that, I suppose. I started my career at the Justice Department in the Land and Natural Resources Division, and I wasn't in the wildlife section, but there was a recent grad from the University of Iowa College of Law that was in that section. Terry Thompson was her name. And she had to defend the Fish and Wildlife Service in a case brought for failing to do a biological opinion, I think, or designation of critical habitat. I can't remember what it was, but it was out in Arizona and they got sued in Arizona. I'm not sure it was your organization, but I remember that she came back from Arizona and she'd been before this federal judge in Arizona, Judge Mickey. And Judge Mickey had basically told her she was trying to advocate. She was just representing her client in the courtroom. And the judge said, you know, Ms. Thompson, I'm running the Arizona prison system under a consent decree. There's no reason I can't run the Fish and Wildlife Service too. As a young lawyer, 2 to 3 years out of law school, that is not what you want to hear from a federal judge. I have to tell your client. And Terry's now a doctor in Iowa City. I'm not sure, is that case with her to medical school? I think, Kierán, you may get credit for this wonderful doctor that we have in Iowa City now. But there's a resource question here. I mean, my sense from the case back then was that they just weren't devoting the adequate resources they need to do to get the job done, but they were devoting those resources somewhere else and trying to do the same kind of thing. So can you talk about the resource questions here?
I will. The first one, shout out to Judge Mick. He's dead now. Amazing character. He put the whole prison system under his jurisdiction. But I remember we did one case with him. He had a cabin up in the woods. We didn't know that he was a judge in Phoenix, and we were suing over this timber cell. And he's like, "Well, let's go do a site visit." And at the time, it's very unusual. I later found out he had a cabin up there. But as we got there, the Forest Service, and it was a fight over. They were claiming that the trees were all infected with mistletoe. It's killing the trees. They need to get in there and cut them down so that they wouldn't die. And so we get out there, and the judge is like, "Well, where is this mistletoe?" You know, try to give him the glasses. He's like, "I don't see it. You know, where is it?" And the Forest Service says to him, "Well, Your Honor, it's latent mistletoe." And self-imposed starvation. So the Fish and Wildlife Service, every year, dozens of cases. We don't have that one. Well, the Fish and Wildlife Service asks for a certain amount of money from Congress every year. If you go and you track it down, you see they didn't ask for enough money. They have all these cases going. They have a known backlog. They know what is going on. But they're purposely not asking for enough money from Congress. You can't expect Congress to overrule you and give you more money than you asked for. Right? That's not going to happen. So they are purposefully underfunding themselves in order to have an excuse to not be able to do the things they're required to do. However, Endangered Species Act, best available science, doesn't anything about best available budget. So we've been very successful in getting the courts to say, look, this says you have to do it. Okay, I don't care whether you get the money or not. That's what it says. The lack of money is your problem. Go find the money. And so we've been able to overcome that hurdle. With some other laws, it can be harder or even not possible because they don't have that clear distinction from budgetary factors. And then the other thing we've seen is, of course, that once there's a court order, suddenly the agencies find the money, right? Money becomes available. And sometimes even, this is not that uncommon, the court order agency doesn't have the money, and a congressman will step in, or congresswoman will step in and get Congress to make the funds available. And they're only going to do that if there is a harm to them in not getting done to require action, right? And so this is where the issue of injunctive relief is extremely critical, because if you have an injunction on the mine, timber sale on the road, it can't proceed until you do what you need to do. So now the forces that are opposed to you are going to want to seek out and get that money available to get the thing going again. Whereas if you get the ruling and there's no injunction, the action's going forward, they don't have necessarily an interest in finding that those funds. And there has been a great erosion in my 33 years of this work in the ability to get injunctive relief. The Supreme Court has steadily eroded that ability. We get injunctive relief much less often than we used to do, and it's part of a whole system of things that has come out of the Supreme Court over the years to essentially, when it can't get rid of the laws, what you can just do is make them non-functional. So standing becomes harder and harder all the time. So you can't bring the case, or you can bring the case, but you can't get the injunctive relief. And so that's been a bad trend in environmental law, unfortunately. And then again, going back, just deal with the money issue. Some things you can look at strategically when bringing a case. You look at situation, you got a mix of different parties involved, they're all somewhat culpable. But then you see, okay, well, which one has the most funds? Example, it's Department of Defense in the mix. And then, by getting the right mix of defendants, you've got defendants with more funds, you've got defendants with more political power. They can be used in the direction you want, or it can go the other direction too, obviously. But to make money appear, because when the Department of Defense is threatened with being able to do the things it wants to do, you can bet the Department of Defense finds the money that needs to be found so they can get back to business.
Thank you. Let me talk a little bit about politics. You mentioned Reagan and Carter and had sort of different impressions of each of them and the way things they did early on in the ESA. Some people might think that it's sort of all flowers and sunshine when a Democrat administration is in control. You've been just kind of talking about the government generally. What do you see as the difference between a Republican administration and a Democratic administration? And are they that different, or is there a big difference in this area or not?
Yeah, this is definitely a complicated question. There are big differences, and they're very important and unfortunate zone where there's not. And so, on the difference side, yeah, I mean, we, Republican president gets elected, and there's just going to be a slew of new rules and policies coming out of the government, all designed to eliminate, avoid, minimize, environmental protection, and they're very activist oriented. I mean, they get in and they swiftly, strategically, aggressively to do these things that undermine environmental protection. A Democrat comes in. Democrats are not swift, strategic, or aggressive. Gotta say, it's one of the things that's really been frustrating. So, we often have a Democratic administration come in after the public and Republican, and they're generally sympathetic, but they just don't have that activist bent that the Republicans have. They're agonizingly slow to just overturn the bad stuff, never mind pursue good new stuff. So one of the big differences is Republicans are activists and Democrats are not. And we've just seen that over and over and over again. But the other thing is that deals with a lot of really specific stuff. But at a deeper level, the Democrats are so beholden to the big corporations. They're so under intense pressure, and the amount of litigation we do under a Democratic administration is not less than it is under a Republican administration. Different kinds of suits, but they're still, at the end of the day, representing some capitalist system that is destroying the planet, and they're not rushing in there to just was going to say to sink the Titanic, but I'm not sure that makes sense. But they're not rushing in there, to change things. So there's a ton of problems. In fact, we face this as an internal political problem every time a Democrat gets elected, because our allies, interest on environmental business, or now, and we're like, gotta do a thing here, folks, and so there's always like this halo, right? There's the window where you're like, oh yes, Joe Biden will definitely save the planet, no question about it, right? But that window gets smaller and smaller and smaller, right? And it turns out for some reason I was just like, we're always the first group to be like, okay, party's over, folks.
I can vouch for that.
Yeah.
I ran the transition team for the Department of Interior, and I met with Kierán. I was meeting with all the green groups, and Kierán was like, he was no more charming in that meeting than he had ever been before. He was like, "We're going to sue you." There's going to be a flurry of litigation. It's like,
no, see, you were in the window. You were in the window, and I was like, dude, the turd is approaching the punch bowl. And she's deep. It will reach the punch bowl. Okay? You got to do something. But there you go.
We talk about politics, but let's take it now. We sort of a little bit beyond politics and talk about, it is hard for any administration to get anything done in this area quickly or not, but because there is each agency has most of the employees of the agency are going to be the same, whether it's a Republican administration or a Democratic administration. Can you talk about the career staff and how they play into these decisions?
Yeah, that's a very important thing. I think a lot of people don't appreciate how important and sort of steady state the government employee system is, because the elected folks and their political appointments, they're just coming and going every 4 years, and it's the career staff that are in there under Republicans, Democrats, whatever, decade after decade. They're the ones that are really running the show, and they're the ones with the deep knowledge as well. And so they're incredibly important. One way we saw that, I think it became more obvious maybe for the first time, but when Trump was elected, the career government employees, they just got roadblocks left and right to him, which they're able to do, and I would say there's their job at some level, So the ability of individuals to come in and get elected and make big change is much less than people think it is, and when you do see it happen, it's a rare figure who knows really how to manage people, manage agencies. So when the Department of Interior, so the last really effective, and on either side, good or bad, the last really effective Secretary of Interior, that was Bruce Babbitt. And he came in and he got a lot of change done, but he was personally invested in it, very hands-on. He really understood how to work with the system and manage the career staff to make things happen. And so they're critical, and if they want to do the right thing, the career staff I'm talking about, they can make it happen. Unfortunately, if they want to do the wrong thing, they're going to pursue that under any administration. So if you take protection of grizzly bears and wolves, we've been having the same fight, with the exact same fight with the Republicans and the Democrats. And that's because the career staff believe in this. And they're going to push that under any administration. And so it's a place where, the position of the career staff has not helped us, but in others that do it. So it's important for us to work with them and meet with them a lot, but it's an very important part of the system that gets overlooked too lot because they're quiet and they're quiet. Their job in many ways is not to be in the media, and they're not.
Thank you. And in just a moment, I'm gonna ask if anyone from the audience has questions, and we will pass around the microphone if anybody does. But I want to ask one more question. I'm Native American, and I always need to insert, my own sort of values and goals into these discussions. And last year, I wrote an article about tribal co-management of federal public lands. And one of my arguments there was that, a lot of tribal governments, a lot of Native American communities think of wildlife as relatives, as part of their kinship network. And I thought, how well can tribes steward species and lands if they view the species and features of the land as their relatives? And my argument is they could be really good allies to the federal government in conservation. Will you briefly comment on your own sort of experience working with tribes and being allies with tribes on these kinds of issues?
Yeah, we do a lot of work with tribes, like a tremendous amount of work, and we have since we first started our very first battles, even before we were officially the Center for Biodiversity. We're over Mount Graham in Arizona, which is the sacred site on federal land where telescopes are being built by the Vatican, among others, and that fight. In fact, when I started the center, I was working in my doctoral dissertation on the relationship between extinction of species and extinction of languages, because languages are actually going extinct on the planet faster than species are. We're living in and have now for a long time a period of just utter devastation to linguistic diversity on this planet, and of course with that devastation of cultural diversity on this planet. I think if civilization is functional enough to still employ anthropologists, anyone 500 years from now, I think when they look back at this time period, I'm thinking now in the last 400 years or so, I think it'll be characterized not by use of technology growth and so forth, but I think it'll be viewed as the mass winnowing of diversity on every level. Species, languages, the cultures. And there's about 5,000 languages on the planet today. 95% of those are spoken by 2% of the people. Everyone else is talking the Walmart languages. French, English, Swahili, Mandarin, big languages that are wiped out, everything else. So that's what I was studying when I started the center, and we named the center, Center for Biological Diversity, as opposed to a lot of other things, right? That the Wilderness Society, the River Network, there's a lot of things you can focus on. We're not even the Wildlife Society, we're the Center for Biological Diversity, because we realized from the beginning that what's critical about the species that we're trying to protect is having them produce this diversity. That's fundamental. That's the fundamental object. That's the fundamental thing that makes the world functional is diversity. It's not things making up the diversity. So So because of that, from the very beginning, we've always had very strong value of protecting and working with and helping tribes that are also being encroached upon and wiped out in so many ways. And in particular, the tribes have been pushed back to these reservations, and even most of them are very small. Even the big ones are just a small portion of the land that the tribes formerly are ranged over. And so our public lands today are all portions of former native lands, and very, very often contain important cultural and religious sites that not just sites, but also species, places where the species live that are the relatives of the tribes. And so, so that's in particular the zone where we mostly worked with is what can we do about protecting public lands such that the sacred sites, the relatives of many people are harmed, and also to give them not just a voice, give them power to manage those lands. And you're talking about co-management. We don't want to talk too much time with this, but the government has specific legal and presidential orders about protecting sacred sites, also about consulting with tribes when impacting things related to them. And they're just not, it's just not happening. Often doesn't happen at all. Most times when it does happen, it's a joke. And it's something that could be done, should be done, but it's just a product of ongoing colonization that they're not doing it. And this is certainly one area where we could have a tremendous amount of change and improvement. We have the very first Native American Secretary of Interior, Deb Haaland. You would think this would happen, it's not happening. Unfortunately, she's just, back to what I said before, Democrats aren't activists. She just is not like a firebrand, and they're pushing a slew of nuclear things. Policies have come out. They're very general, and we're just right now missing an opportunity. It's not too late, definitely not too late, but it's not being pushed nearly as hard as it needs to be right now.
All right, we have less than 5 minutes left. Yeah, who has a question? Yeah.
Thank you very much. Is it on?
Yeah, it's on.
You can hear me? Okay. Thank you very much for being here and for presenting this. Synchronistically, I ran across a documentary yesterday called Racing Extinction. Are you familiar with it? I'm only about 2/3 of the way through it. It's powerful, it's disturbing, it's got a global perspective, and it's available on Canopy, which is your library's free movies. I really recommend it to everybody in this room. Watch it. It's really, it'll get you. It gets you in the gut more than stats.
Thank you for speaking with us. I was wondering if, as an organization, when you're allocating resources, you ever have to prioritize one species over another, and what factors you use, if so, like genetic uniqueness or prospect for recovery?
Yeah, we do. We have. I mean, we work with hundreds of endangered species. We're tracking thousands, so we have to figure out where to intervene. Most important thing to us is, well, simultaneous talk, right? But one would be, level of imperilment, right? When a species is really imperiled, there's projects coming up that is just going to take a huge bite out of any population. That always just goes to the top of the list. I mean, history has shown that there's no species that's not recoverable. I don't believe in triage in that sense. Species have been recovered from the tiniest possible population. So we never write any species off. So imperilment is big one. Second is simply continuity, meaning I've been around for 33 years. A lot of species I'm working with, I've been working with for all 33 years, you know. So you build up, you sort of, you know, for various reasons early on, you become the protector of that species. Other people don't work on it because they know you're working on it. And so you got a certain momentum. Take Mexican spotted owl, if you like, they have a whole bunch of yellow-billed cuckoo, southwest window flycatcher. These are all species that we become the protectors of. So we're always going to work on that because you know, we need to do that. No one else is going to. The tribes will come to us fairly often with wanting us to intervene, and in that case, that's a high level of priority. So the species they wants to work on maybe isn't the highest level, but the fact that the tribes want it puts it at the top of the list. So we have that, and then another thing comes into play. So we work on all endangered species. Like we truly believe they all are equally important. They all are equally valuable. And so, you know, the Mojave Band shoulder snail is as important as the polar bear to us. And when you're looking at, like, say, critical habitat designation, the Mojave shoulder band snail, the 10 acres that it needs to live, those 10 acres are as important to it as 20 million acres are to the polar bear for what it needs to live. So that 10 acres is as important as those 20 million acres for that perspective. And we're one of the few big groups that does work on all those species and values them. And so that's important because on some of the bigger, more charismatic species, we know someone else will come in, defenders of wildlife. We don't do it, they'll do it. Whereas if I don't do the shoulder band snail, no one will do it. So for that reason, we also tend to prioritize these endemics where it's just, we have to do it because no one else will. That's important. All right.
Kierán, if we stay in this room much longer, you're going to have to teach torch to the classes that come after us.
But I can do that. But tell the next class it's endangered species. But I'm going
to step outside and we will take questions or comments. Listen, can we all join me and take